Disciplinary Advisory Committee to the Veterinary Medical Board. I'd like to start with roll call and establish a quorum.
Okay, Dr. Klingborg.
Here.
Dr. Druces.
Present.
Dr. Grant.
Present.
Dr. Pollard.
Present.
Dave Johnson.
Present.
Christy Pulowski.
Present.
Diana Woodward-Hagel.
Here.
Jennifer Laredo.
Here.
Dr. Sullivan.
Here.
So
Keeps it interesting.
we've established a quorum. At this point, I'd like to invite members from the audience to introduce themselves.
Nancy Earle, California RVT Association.
Cindy Savely, Sacramento Valley Vet Tech Association.
Leah Schufeltz, CVMA.
Alec Henderson, Veterinary Allied Staff Education.
Candace Rainey, board staff.
Valerie Fenstermaker, CVMA.
Ken Pulowski, CVMA. Dan Segma, CVMA.
Joe Waterhouse, VMB.
Mark Nunez, Veterinary Medical Board.
Kelly Jones, PC, Board of Bureau Relations.
Great, thank you very much. Move to item number 3 on the agenda, the review and approval of the April 19, 2016 meeting minutes. Any discussion from the committee? Make sure your microphone's on, please.
Oh, thanks. Christy Pulowski is an RVT, not a public member.
Okay, what page is that?
1.
Okay. Under members present.
Correct.
Okay. Thank you. Any other comments?
Sorry.
Yeah.
I did notice they spelled Dr. Klingborg's name wrong several times.
That goes with the turf.
Yeah, you're at Klingborg.
You don't-
You're at Klingborg.
It autocorrects and somehow Klingborg means something.
Yeah. I'm okay with that. Yeah. Okay, very good. Yes. Oh, can you come forward, please, so we can hear you?
Just a quick correction on my name. It's the Sacramento Valley Veterinary Technician Association. Thank you.
Valley Veterinary Technicians Association?
Yes,
Okay.
under Cindy Savely.
Got it. Other comments from the committee or the audience on the minutes? I would like to thank Nina, the board staff who put this together. It's the most complete minutes I've ever seen. It was exhausting reading, but it really captured everything. Really captured everything that we did. I can imagine. So we need a motion.
Move approval as amended.
Other discussion? All right, so then we need to take a roll call vote.
Dr. Klingborg.
Aye.
Dr. Druces.
Aye.
Dr. Grant.
Aye.
Dr. Pollard.
Aye.
Dave Johnson.
Aye.
Christy Pulowski.
Aye.
Diana Woodward-Hagel.
Aye.
Jennifer Laredo.
Aye.
And Dr. Sullivan.
Motion carries. Minutes stand as approved. We're on to item number 4 on our agenda, an update on the complaint process audit task force subcommittee. Doctors William Grant and Jeff Pollard.
Dr. Grant and I met on June 1st reviewing more closed cases. This time we reviewed a smaller number, but they were all 3 quite involved, multiple cases each, lots of experts and consulting veterinarians. And we came to review a few old conclusions and came to a couple new ones. And I think the highlights are elencated here, but the ones I would just point out for any comment or discussion would be older cases don't seem to have as much value as more current ones, and as we go further in this process, there probably will be more current ones, and we'll also have to come to a decision about how involved and how many cases that are reviewed and what frequency. Enforcement staff has had a training session in May, and there will be another one planned in October, I understand, sometime in the fall. And one of the items that was proposed is that Drs. Grant and I consider presenting some of our findings at the training session. I think the kind of the light bulb, one of the light bulb moments that I had in the most recent review was the realization that when the expert reviews a case, it seems even subconsciously to make a difference in which order of the material he or she reviews, i.e. the complaint or the medical record or anything else. And we had some thoughts, and they're listed here. And, I think the other thing that I'd like to mention is it occurred to me that in most of the cases that we've reviewed now over the last year, it didn't appear to me anyway that many, if any, of the respondents' replies, so when veterinarian has a complaint lodged against him or her, they get a letter from the Veterinary Medical Board requesting records, and they get an opportunity very early in the process to reply, to answer. And for a variety of reasons, we listed 4 possibilities. It just seemed like, at least in the expert witness packet, or in this case, the review of, they weren't their best advocate. They didn't write things, they didn't explain things, and we posited that perhaps they misunderstood the request, what was asked of them. Maybe they didn't take it seriously, didn't understand it. Maybe there was legal counsel that was involved, and maybe there was something else. But if there was a misunderstanding of what's expected, maybe it's something that would truncate the entire process. If it were a more complete reply at the beginning, maybe they wouldn't even go past the enforcement desk. Those are our thoughts.
Bill, anything to add?
I think Dr. Pollard really covered it. This last one, while we didn't get through a lot of cases, the cases that we had, there were 2 on 2 of the 3, so that was really more like 5 cases. But the meeting, I thought, was extremely beneficial, probably the most beneficial, with both Candace and Anne Marie and Dr. Pollard and myself, where we had a chance to really look at the process. And there's things I think that the board can do with training, and there's some things that I think that the board can work with the process, but we've had an opportunity, which is, I think, incredibly unique, to take, the true Monday morning quarterback look at how everything went through, and then what the end product was in the decision-making process. And it's, I hope, and we shared this in our committee, that this needs to go on. This is a great opportunity to help and better what's happening with this. So I think Dr. Pollard really covered it. And as I said, I thought it was probably our last meeting was the most beneficial one we had.
Questions, comments from the committee?
So is it within your purview to then make suggestions as to how the process could be improved? I'm thinking more along the lines of educating the licensees on potentially how to deal with a complaint, so that essentially their best foot forward position is taken right from the start, instead of having to play defense or not having any defense at all.
Well, I think we were tasked more with reviewing things on the VMB's side of the world. I don't know how you tell 12,000 veterinarians how to do it right. So I think that's probably a bigger call and a bigger committee and many more meetings. But I wonder if perhaps in the formal letter in response to a complaint that goes to the respondent, there couldn't be some language or some way to inform respondent differently than what's being done now.
That essentially they should be taking this very seriously and not delaying a response or not responding at all.
Right. So we have done some outreach, Candace and Ethan and I, on an annual basis, actually the last 2 years and maybe 3 years, have met with a legal firm that works with CVMA. And they provide a certain amount of free legal services to members of CVMA. And when they meet with us, their goal is to find out what they can do to educate their members on working with the board on issues related to enforcement in particular, but sometimes it's CE. And so the message consistently has been respond to the board's inquiries, provide statements. It doesn't benefit you to, when the board sends a question or an inquiry, to lawyer up and not respond, because at that point the board has no choice but to pursue the case. We have no choice but to continue the investigation. If we don't get responses, then it goes into perhaps a citation or some other form of legal recourse. The statute actually, it's in regs, and I know there is a statute that supports it. It's a requirement that you respond to the board's inquiry, and especially when it comes to records. So it is a message that we're getting out there. The, I think, unfortunate thing is that even before the board is in a position to be pursuing legal action, we're already confronted with opposing counsel and request for information going to counsel instead of the licensee, and that's premature. We're not there yet. So we will get a notice of representation when we don't even have an enforcement issue. So, I mean, it is just the culture, and there's only so much we can do to help influence people to respond to the board. Granted, it's probably a scary thing when you get a letter from the board saying, we need your records for this animal, but when you refuse to respond, you put the board in a position where we have no other choice but to pursue it from a legal perspective.
That, I think it's probably the same firm that has put on programs now at the CVMA, and not this year, but the last PACVET meeting, I attended their, it was called their inline program, and the firm of insurance people and attorneys gave presentations on various aspects of the process, and I thought it was excellent. I thought it was fascinating, just out of my personal interest, but I think it was very helpful. And Dr. Sullivan also attended, made the very seminal comment. He said, this room should have been standing room only, and it wasn't. So whether it's interest or lack of awareness or it's not going to happen to me, I think there are probably multiple factors, but it was revealing that there were many, many cases that just could have gone better if perhaps some things would have been handled differently at the early end of things. Completely apart from the medical care of the case involved.
You had mentioned the order that the materials are read can influence that. Are you suggesting this order here is written in the packet?
Actually, that's just one option. Dr. Grant and I just discussed this a moment ago, actually. As unbiased as we pretend to be, I'm sure, one, we're all colored by our own experiences. Two, we're veterinarians. And it's probably going to be different for different individuals. And I would think at least this order, complaint, investigation/inspection, expert witness report, and then the hearing decision. This is somewhat colored by the fact that we're reviewing closed cases. The expert is not going to have that resolution, of course, so they're only going to have, but they're still going to have several pieces of the pie. And I think we both concluded that probably, for us anyway, an order that would be fairest, if that's, if that's a parameter, would be to read the medical record first, and then follow it with the complaint or any inspection or any investigation work. And I'm certainly open to discussion or other arguments, but it's hard to be completely unbiased.
What, and just to ferret this out a little bit further, what we're talking about is if, I mean, there's 4 or 5 veterinarians here. We all could do the exact same thing, and yet the outcome of the case may be totally different for 1 or 2 of us. That doesn't mean something necessarily was done incorrectly, but the outcome has changed. So our point really is if we look at what the veterinarian he was presented with a problem, or he or she presented with a problem, there was appropriate rule-outs, there were appropriate diagnostic tests, and then the treatment should hopefully fall in with what the group or standard of care assesses. If you read a complaint, we think that you're going to be unfairly motivated to look at why or what happened wrong. We're not talking about necessarily what happened wrong. We're saying, did the veterinarian follow what he or she should have followed within the standard of care? And if they do that, then read the complaint, read the expert witness, read everything else. You can follow whether or not that veterinarian is outside the standard. And it's interesting, when we sit down and read these cases, you can see those cases where the opposite occurred. You know, they read the complaint, or there was a expert witness or whatever that they saw. They probably are not going to see the expert witness portion of it, but they will see what the complaint was. And as I said, I mean, and I think Dr. Pollard would probably say the same thing. There are things in those complaints that I look at that I said, wow, I've done that. Been there, done that. Thank God this wasn't the outcome, but you know what? This is not outside of what we do here. And I think when, actually it was Anne Marie, I think, that brought up the point, you know, maybe taking this information, for this information, for what we're doing here to just stop at this committee is a huge mistake. What a waste of time. This needs to go to the people that are working on this and let them have the benefit of what we're learning, because they're the people that are driving the process. I think having Candace there and Anne Marie is critical, because this is what these guys do every day, and so they need to be a part of it. But I also think that the people that are doing the expert witness, they need to have the benefit of what we found. It has, I think if somebody said, what one word would you say when we looked at this? This is an eye-opener. This really is, and it's a very unique opportunity to educate, hopefully, the people that are involved in the process.
What's the next step for this subcommittee?
I think continuing to move forward. I think if it does work out, to be a part of the training and see how that works, and to continue to try to understand the issues and what good things and what things that we can improve with. Honestly, this has been a huge learning curve for Dr. Pollard and I. I'm not sure that we completely even understand all of the issues. Dr. Pollard and I just talked about, Candace and Anne Marie have provided, the cases that we've looked at. I'm wondering if we should take a random look at cases. In other words, every other one, maybe just do something a little different, have a different perspective on what cases that we're seeing. So it's evolving, it's changing every day. Hopefully we can get to a point where, as I say, we can affect how these cases are handled and make this process better for the complainant or the respondent. It's really huge, and I think Dr. Drusi touched on it. If we can also, at some point, I think it'll be much more of a challenge to help the respondent. And I'm not sure how to do that. That's gonna be the tough one. The in-house affecting change is gonna be big, but I think the committee needs to continue doing what we're doing, and hopefully it'll benefit the whole process.
Can I ask a question? When you said help the respondent, at what stage are you concerned about in the process?
I think just responding to the state board, and maybe there is a statement that can be put in there of maybe what they should address. I'm not saying it needs to be some cookbook response, but Dr. Pollard is exactly right. Some of them, actually, they didn't help themselves. They did disservice to themselves. And I would rather, hopefully that wouldn't be the case.
At the very beginning.
At the very beginning, at the very outside. And unfortunately too, hate to say this too, we've seen cases, there has been horrendously bad legal advice. That's painful.
Right.
I want to address the randomness of the cases you reviewed. Early on, we did a date range. Remember, you guys kind of set the parameters. You said we want to look at this date range, and we want to see cases where, we kind of have a variety of the complexity of the issues. So they were somewhat random, and then in that random selection, we had to go through and look at cases that were actually, there was adjudication, there was an expert review and an outcome. So they're not random, they are random. There is a random selection, but when we do the random pool, if there's an expert opinion and then nothing beyond that, it doesn't do you any good to audit it because you need to see a decision. You need to see what happened to the case.
Right.
So as much as we can, we are random in our selection, because what we don't want to do is taint the process by saying, oh, let's handpick the ones that aren't so embarrassing and have you look at those. We want you to see the worst of the worst, and hopefully in that you see the best of the best. And I think as we get more current, you're going to see much better consistency in the outcome of the review. I do also want to address something that comes up often in the training sessions, and I say often, we've only had 3 of them since I've been here, but this kind of common, I think, question from our expert witnesses is this: I'm not an expert in this particular area. I've only done a handful of these procedures, and they don't understand, and we're helping educate them. They need to turn that case back over to us, and we need to find another expert. Expert witnesses have a misconception that once we send them the case, and because we have now identified them as experts, that they're obligated to weigh in on all these cases. And they're not. We don't want them weighing in on cases that they're not expertly, competent to weigh in on. The other issue that comes up that's an important issue that I don't think we've really ever addressed except with this last training is, how many people do you survey to get your responses? We have expert witnesses that you're supposed to use some form of research. If you're relying on something, you have to cite it, obviously. But if you're starting to poll people in your office, if you're starting to poll other veterinarians, there is something that's called into question here as to whether or not this is your opinion as an expert, or whether you've just now surveyed a group of individuals and who really should be called on the stand to testify to this standard of care. So it is extremely complex, and all of you sitting here know you're not an expert in everything, but you're extremely bright and intelligent, and you practice good veterinary medicine. So at the end of the day, I could send any one of you a case, and you could look at it and say, shoot, I don't know, I've got to call so-and-so down the street, he does this more than I do. It's okay to do a bit of research, but at some point, if you're relying on the opinions of other people, you're no longer the expert. And that gets us in trouble with the validity of our cases. You know, what we don't see often is those cases being fully adjudicated. What we see is stipulated settlements, right? Where the two parties agree that, okay, I probably didn't do this right, the expert said I didn't, so let's just come to terms and let's move forward with this, I want to be done with it. But if those cases went to hearing, and there was cross-examination of our expert who relied on 4 or 5 other people to formulate their opinion, what happens to our credibility? So it's really important when we train our experts to help them understand, first of all, they're not obligated to weigh in on a case that they're not comfortable with, and secondly, if they're not formulating an opinion based on their own expertise, they may want to recuse themselves, or not recuse themselves, but turn the case back over to the board so that we can find someone that is. And I think our training has, I know, our training has improved dramatically. The last training session we had, Diana was there, Diana was there, John, you were there, Klingberg was there for a day, Christy was there, yeah. There's a great deal of dialogue between the experts about what they don't know. And it's important for them to be able to have that dialogue. It's important for them to be able to understand on the stand and during cross-examination what they're to respond to and how to respond. They need to understand, we want your professional opinion. What we don't want is your bad experiences and things that you've seen in the past, because this isn't about anecdotal stories. This is really about standard of care. And I know Kurt does want to address something, and it could have been it probably is the way I wrote it in this memo. Dr. Grant, Dr. Pollard, Candace, and I spent a lot of time talking about correlation between standard of care and a bad outcome, and whether or not we make that nexus. We connect those two things. And I want Kurt to touch on the outcome doesn't necessarily, the outcome has something to do with why we move forward with a case, but not everything to do with it.
I would defer to Ms. Rainey and let her go first, and then I'd like to go last, so she, looks like she's eagerly anticipating something, so.
Just a couple of comments. I agree that this process has been enlightening. It's also been enlightening for us, and that it is a unique opportunity, so I look forward to continuing it. We're learning a lot through this process, and the expert witness training was great because we're seeing what are the challenges that are coming up that the experts are facing, what are their questions, what are their concerns, how can we better address that. So, you know, the past couple of years have been banner years for us when it comes to adjudication of cases, so what you're going to start seeing are more recent cases. Obviously, we have to wait until there's they've exhausted all avenues of appeal or that time has elapsed before we can start reviewing those. But I think the next year is really going to be monumental. I'm looking forward to it.
There's sorry, you're next. There's a note here about looking at the motivation for a complaint. How is that, what's that process within your shop?
We get complaints for a variety of reasons, obviously, but oftentimes the motivation of the individual filing the complaint, we take into consideration a myriad of factors, of course, and that's one of them, because if their motivation is to get their money back, which a lot of times financial is their motivation, if they didn't get the outcome that they were seeking. We've had complaints where they're filing, you know, it's one practitioner filing against another. So that's always a consideration, and it's always something that's looked at when we're looking at the complaint and what to do with it.
It's a motivation for us as staff. It should not be a motivation for our expert witnesses. And the reason
Right.
being is that the expert is purely looking at whether or not there was a deviation of standard of care, regardless of the motivation for the filing of the complaint. complaint.
Exactly.
And that really speaks to the correlation between, was there a deviation of standard of care and is it tied to a bad outcome? So let's say there was a deviation of standard of care, and you touched on this, Dr. Grant, and by the grace of God, this pet is still perfectly fine. Does that mean we wouldn't pursue a case? Likely, we wouldn't see the complaint to begin with because there was no harm to the pet. But on the off chance that we did, and we still see that there was a deviation of standard of care, we have an obligation to pursue that. So it is something, there is a correlation sometimes that you kind of connect those dots in your opinion. But we have seen where there's things that were done wrong and the outcome of the pet was still positive. There are times where things were done right and we saw a very bad outcome.
Negative.
And a very negative outcome.
Mhm.
And in those cases, we can't pursue that, nor should we. I mean, it's hard to explain that to the consumer because they're left with a deceased animal or an animal that, is harmed or impaired for whatever reason. But deviation of standard of care, regardless of the outcome, is what we're looking at, what the expert's looking at. So, it's really hard to change that frame of thought for an expert who's not experienced or well-trained in this. Because again, what you're looking for is a fact pattern of, these are the facts and this is the end result. Sometimes they add up and sometimes they don't. Motivation is something that the staff looks at as to whether or not the complaint should be pursued, but it's not something we want our experts looking at. And that speaks to looking at medical records first, I think is a very good idea in terms of how the review happens, because then it's just this fact pattern of evidence-based, here's what's in the record, and then move from there.
Excuse me.
Ellen and then Diane. Okay.
Yes, that touches on one or two things I wanted to ask or bring up. So the cases that have been reviewed to date, are they all cases where the licensee has had a negative outcome in the case? Or there have been cases where the licensee has been relieved of any guilt or penalty or negative outcomes? What's the ratio of these kinds of cases?
All of the cases had some level of penalty assessed. But as Anne Marie just pointed out, not all of the patients had a bad outcome. And it's a quandary sometimes.
I guess my point would be that at some point down the road, perhaps, I think we should also be looking at those, as we want to complete the circle, look at those cases that have been brought forth where the veterinarian has been vindicated, to make sure that at least that part of the process is also being looked at, evaluated, and critiqued.
I think in one of our first reviews, and Dr. Waldron and I, in the last two, we've gone through the exact same cases, but in the first one, half of them we did were similar, and then the other half that we did were separate. Part of it too, and you say vindicated, not vindicated, there's a lot of different levels. There's lost your license to something a lot less than that, probation, so on and so forth. So I think there's a varying degree of severity of the outcome of the case, and my recollection was, I think I saw at least one, possibly two, that they investigated and there was really, it wasn't a negative outcome. It was just, they investigated the case and that was it. Now, I think almost every one of them was an accusation. I don't remember seeing anything out of sight and fine, but there were a couple that the outcome was not a negative outcome. And that's exactly my point, Alan. I think that you're getting at. You know, it's the process. It did the veterinarian, and Anne Marie's comment was spot on just a second ago. It's how you got from point A to point B. It's not necessarily what happened to the animal. It may have absolutely nothing to do with what happened to the animal. But if you did the right thing, thought the right way, we all went to different vet schools. Some of us went to much better vet schools than others. However, we learned the same process. And you know, how do you solve the problem? We're all pretty much, we're taught as scientists and problem solvers, and we should, in general, be doing this the same way. And we're gonna have different outcomes, and we're gonna have different scenarios, but, you know, if this veterinarian that they're looking at did the problem-solving algorithm in a similar fashion to what we would have done, you know, unfortunately, some things are going to die. And that's the way it is. There's thousands of people a year that die from aspirin and Tylenol. That's the way it is. There's some things that we can't change because of the biological system. Agreed.
Diana and then Christy.
Well, I'll be the surrogate Diane Sokoloff here, talking about a bad motivation to file a complaint. And it's true, it's not the expert's problem. They just evaluate what they have in front of them. But it is the DAG's problem, and it's called bias when you're in a hearing or looking to a hearing. And that may affect a recommendation to settle. And oftentimes, if the case is heading for a hearing, the first time anybody ever sees the complainant, let's say, in person, is the DAG when preparing for the hearing. And if the complainant, who may appear reasonably reasonable on paper, is completely unhinged when you're interviewing them before the hearing, you know you've got a problem. Because if there's opposing counsel, they're going to hone in on that bias and may, you know, be a good idea to really talk settlement because you've got a poor witness. But if you've got a poor witness, sometimes that's just the way the mob flops. And you hope you can make the best record you can, working around the bias. Even paranoids have enemies. And the jilted, you know, ex-lover who files the complaint may have a legitimate complaint. And it's just a matter of argument and how you present the case. But it's not the expert's problem.
Right.
Christy and then Jennifer.
I was actually just going to state that Diane Sokoloff does a really good job in the expert witness training of explaining motivation and going through outcomes. So it is very nice during the expert witness training explaining that. So anybody who has not attended the expert witness training should know that. It's very clearly outlined.
Jennifer.
I wanted to say from a board member perspective, we're not
Your
given,
mic on.
yeah, sorry, I'm a low talker.
Okay.
From a board member perspective, we're not given all of the information on how the expert arrived at the information, we're just given specifics. And without disclosing any specifics, there was one case in particular that the motivation for the complaint was questionable and there was a negative outcome. And the board expert witness was a general practitioner who just focused on this negative outcome. The respondent in this case had his own expert witness who was board certified, and this other expert witness gave a more clear picture of the whole. So the point being that had our board expert witness focused on the entire case and not just the one specific negative outcome, it would have made the case a little stronger rather than trying to justify discipline.
Oftentimes there's a reason that you're right, you're not privy to as to why the focus was only that particular outcome. And it's because the evidence doesn't support the other allegations. And so the only thing that we can proceed on is whatever that particular, you know, circumstance is. So if there is more than one violation that either the medical records speak to and support, the expert is, you know, we focus on that entire set of circumstances or set of facts. So sometimes it has to do with how the case is being prosecuted as well, if we have a lack of evidence in some areas.
David.
I just had a question of curiosity. Have any complaints against RVTs been reviewed at all?
No, we have not had RVT cases, but that's a very good idea that we should include that. At that point, though, I think to be fair to the professional community, we should also have an RVT be auditing those cases. So if we're going to go down that road, then we would look to either Jennifer or you to serve as an auditor. Sorry, you're still the public member.
And one of the things that we had discussed in your subcommittee were term limits. And so we'll have a discussion off camera at some point. Bill and Jeff and I will sort that out, figure out how that works for the subcommittee going forward.
Dr. Klingborg?
Yes, Diane?
Kind of keying off the knowledge of the expert or the influence of the outcome of the case to the expert's review. Is there any concern about the disciplinary guidelines and the expert's knowledge of that? Now, I realize that's a matter of public record, but what's the feeling of the committee or the subcommittee about that? Does that influence, did it appear to influence expert witness reports?
And we were just chatting about that. That is an issue that we have seen in some cases where the expert witness, we're not sure that the statute was applied maybe as it should have been. And I think that's a training issue that we've discussed, and I think that hopefully that can improve with time. But again, in general, and I don't know if we brought it up, but you know, the older cases we looked at, there's literally a world of difference. It's hard to tell exactly when the change occurred, but certainly in the last couple of years, the product that this staff and this board is getting is totally different than what was going on even as recent as 4 or 5 years ago. I mean, it's just it's a different product. But you know, we did talk about it. It isn't a concern that we had, and we discussed it with Anne Marie and Candace.
So, Diane, the expert does not recommend a penalty.
No, I do understand
Yeah.
that, but as I recall in the disciplinary guidelines, there are these huge ranges
Right.
of penalties. And sometimes people go immediately to the top range and say, I'm just wondering if somebody is looking at a possible negligence conclusion and saying, oh my gosh, it can be, 15 years of
I
suspension.
got you, whether it influences them.
Right.
So I don't know that we've addressed that with the experts because we try not to focus on the disciplinary guidelines because they're not the decision makers.
Exactly.
We do try to
Right.
focus on in the last training, I think we did a really good job of outlining all of the statutes and regulations, and Christy and John, you were there for that part, and we had them tab each of the sections that they typically rely upon to come up with their conclusion as to whether or not standard of care or deviation of standard of care was an issue. So, and it covers anything from fraud, negligence, incompetence, unprofessional conduct. So there are several layers, and what we want them to do is get extremely familiar with the Practice Act. What we don't want them to do is focus so much on the degree of discipline.
Right.
Because at that point, they've moved beyond their role. You have to think about this as a continuum. Everyone has their individual part, and at some point, all of those parts are, they flow together and we have an outcome. And staff is one part of the process, investigation is another part of the process, expert review, legal counsel in terms of review and preparation of an accusation, then obviously whatever adjudication comes from that. But the expert witness, if they get too far into investigation or if they get too far into deciding what discipline is warranted, they're outside their role of expertise, and it also would very much impact or in some ways I think it would probably skew their professional opinion about the facts of the case. So it's important that they stay in their lane for the reason that we don't want it to influence their opinion. We don't want them to see, oh my goodness, if I say this, someone's going to, lose their license. They don't know that first and foremost because they only have so much of the pie at that point.
Right.
And they also aren't trained to, draw those conclusions. So it's really important they're aware of them, but we don't focus on them in the training.
So I'd like to hear from legal and then give the audience an opportunity to talk. We'll get to you.
Thank you, Dr. Klingberg. I think that's the first time that anybody ever said they'd like to hear from legal. Let me take things in reverse order, if I may. First of all, my presumption is, let me give a disclaimer. I work in the adjudicatory phase of the traditional three-part licensing discipline model, which is investigation, prosecution, adjudication. I'm only involved in the last third, the adjudication. So let me first of all say that my presumption is that the fine work of the review committee or subcommittee has done, it has the effect of percolating up to the recruitment and training of the expert witnesses, a sort of continuous loop, if you will. You find something, it comes here, then it bubbles up to Ms. Rainey and Ms. Delagnaio to the folks that are most interested in the interested parties. Is that correct?
Correct.
Okay. So the second thing that I hate to be the wet blanket of the contrarian, but I want to be very careful in my remarks, and this is say there was a suggestion that somehow we help the respondent, and I urge a certain degree of restraint and discretion with helping the respondent. I think the board would empower to be in their communications with licensees and with respondents and say, as many times when you issue a citation or whatever, say, please tell us your side of the story. In fact, that's the purpose of an informal conference, where the person comes to and says, okay, you may have found something, but here's why I did what I did, because it was hot outside, it was an emergency situation, everybody was left-handed, whatever, okay? So I think to the extent that you go out and say, the board would appreciate it, the board respectfully requests every information you can provide, that's most helpful. With the understanding, if someone has lawyered up, they have the right to counsel, they have the right to file their counsel's advice. So I think there's a little bit of tension there as the board moves forward. Let me also go back to on page 2, the top full bullet of the memo. And having been counsel for the medical board and the psychology board of California, I'm going to explain my concern about the motivation of the complaint. A lot of times when you have a licensed healthcare professional, licensed psychotherapist, you have a custody battle between a divorcing couple. And if it doesn't, regarding child custody, and if it doesn't go the way of one of the parents, guess what? You're staring down a barrel of a complaint only for leverage in the upcoming dissolution custody battle. So to the extent staff has a role in ferreting out, that's appropriate. To the extent the expert gets involved in legitimacy of the complaint, not so much. Okay? So finally, winding down to the thing, I want to go back to the 5th bullet on the first page. Expert needs to examine whether deviation of standard of care and so on. So if you think about it, we don't want to get into Morton Thiokol, Endeavor, Columbia situation where we're using outcome-based engineering. And that is, if you think about the standard of care, which is established by experts in the field, the expert testimony in the administrative tribunal, that's a long, horizontal, limitless line that goes out in space. And the expert's job is then to figure out, is there a deviation? Did the standard of care dip, did the veterinarian licensees dip below that? Not so much outcome-based engineering, but whether there is a deviation. Because there's a famous case in case law called Griffiths that says a licensing agency doesn't have to wait for patient harm. Because that's a common defense here. Well, a patient, especially in the human world, also in the animal world, oh, nobody died, it's okay, there's no harm. Okay, that's not, we don't have to wait for somebody to be harmed. We don't have to wait for an animal to be harmed. So to the extent that an expert understands, stays in their lane, understand, I look for the standard of care. If there's a deviation, then I characterize that deviation. And therefore, then the music starts playing and somebody starts singing. Because the expert does not get involved, and I think that person should be revoked. I think that can be a function of a stipulated settlement. That can be a function of a fact finder through an administrative law judge. But the expert has a role. What's the standard of care? Was there a deviation? And then like I said, the music starts playing and somebody starts singing. So I'll entertain any questions, but again, with the understanding that I don't work in the investigatory or the prosecutory phase of things, just in adjudication, but I have a little bit of experience in that area, I will thankfully shut up. So.
Christie?
I was going to save this for the expert witness training part, however, we kind of touched on it with what Anne Marie said. There were many comments during the expert witness training, and most of them were very positive, and I want to agree that all of the expert witnesses were very thankful for all of the training. They had not had the training before. They thought this was wonderful that they were being able to have something like this. They thought, finally, they had been expert witnesses for years, and yet this was the first time they were actually getting to have some type of training. The one thing that I think was very obvious to me sitting there was that they had no idea about the Veterinary Practice Act. They did not know what they were trying to review. And that was probably my biggest concern. So they're looking at cases, but they don't know what they're trying to compare it to. And I think John and I tried to not talk too much about it, when we were there, but it was very obvious when they would look at it and they would talk about it, but they really didn't know how to put it into words or what they were trying to review. And I think that was probably the biggest concern.
Kurt already kind of touched on this, and I don't mean in any way to oversimplify the process, but for the experts, really what we need is them to look at the information that they're handed, determine was there a violation, what happened, what did the veterinarian do, or the RVT, was there a violation, and then explain what was it a violation of and why was it a violation. Or, on the converse, was there not a violation and why was there not a violation? And then, that's what we need, and that's that piece of the puzzle that we're going to take and then factor in everything else. The expert, when they get that report, they don't know if this individual has been cited 3 times before for something similar. So we really, stay in their lane is a good analogy, because that's what we're looking for is what's there. And we have seen kind of a struggle with the Veterinary Medicine Practice Act, and we are constantly reiterating that they need to be familiar with it. That's why we tried to provide kind of guidance as to what are some of the most common violations that we've seen.
That was
and
good.
How to create that nexus there.
Right.
Also, when we're sending cases, and this isn't such an issue anymore because we're becoming more current with our cases, but when staff is sending a case out to expert to be reviewed, we're looking at that and saying, okay, when did these violations occur? And do they need the law book for those years?
Yes.
Or are there laws that have come into effect since then? There have been a number of big ticket items, so to speak, managing licensee, minimum standards, all of those that are really more recent, that you can't necessarily take a violation from 2008, 2010 and apply this law. So there's a lot of work there to be done, but I definitely think that we're seeing progress, and the comments from the experts were invaluable.
Yeah, and them talking about the negligence and incompetence and being able to go over that in the training, I think, was invaluable as well.
That's a common struggle for all of us.
Candace, how many of the experts were there for the first time? Because we've done 2 other trainings, so it wasn't, some of those experts have been trained. I don't want to mislead the public here to think we don't have trained experts. We've already had 2 training. This training in and of itself was an expansion of the program. It was at a 2-day training session where we actually did a mock trial. And we've learned from that mock trial we need to rotate the players. We need to rotate the veterinarian that's on the stand serving as the expert. We need to rotate the opposing counsel position, just so that really everyone gets a feel for what that is like when you are on the stand. Do you know the percentage of the folks there that had been through training before?
I don't know.
Okay. Jeff?
I don't know.
I wanted to reply to Mr. Hebler's comment about my pointing out the ineffectual response letter. I don't say that in so much as the respondent needs more support or needs to be defended, as much as it would make the process so much more efficient if we actually, from the expert witnesses' point of view, from the staff analysis point of view, say nothing about his or her defense and counsel. Just seems like you go back and forth. It's inefficient just on its basis, but you ought to be able to wrap it up inside of a year.
Couldn't agree more, Doctor. In fact, if I can tell you a personal story, when I was counsel to the now physician assistant board, then the committee, the medical board, you would have a series of citations, and then ultimately an informal conference, and it would be a situation where an expert participating would say something like, well, if you'd have told me that right off the bat, we wouldn't be here. And so I certainly understand your point. Like I said, I don't think there's anything wrong with the board saying, the more facts, the more information, just like when you petition for reinstatement, you bring all the evidence of rehabilitation you could possibly think of, because that assists the board. So it seems logical that, the decided person, the licensee or whatever would say, well, here's the universe of things that I considered when I did this. Regrettably, or not, sometimes that doesn't happen, but I don't think there's anything untoward for the board by saying, the better and more fuller, complete picture you can present, we'd be grateful.
Comments from the audience?
I have one.
Let's,
Oh.
we're gonna move this along at this point, okay? So Val, please.
Valerie Fenstermaker, CVMA. First, I want to say I've been involved in a number of discussions on this topic over many, many years, and we do try and work with our members and address complaint process and educate them. And things may have changed from the past to the present because there's a new executive officer and a new legal counsel and so forth. So if I'm saying anything that has changed since that point when I've been involved in discussions, you can just correct me. First point was Dr. Pollard commented on the response of the veterinarian. And in the past, we've been told that the initial letter that whether it's a veterinarian or an RVT receives it, does not exactly state the nature of the complaint. And that is one of the reasons that they are reluctant to respond, because they don't know exactly what they are being complained about, what the complaint is. So there is a reluctance, and if that is still the case, could you address that they don't know what the complaint is? Or are they told exactly what, what exactly they are being accused of, that way they can respond?
That initial letter that goes out generally includes a synopsis of, on this date, this individual brought their animal, named the animal in for, and it kind of gives a synopsis of the situation that happened. And then we ask for a statement and a copy of medical records, generally is what happens. So yes, they should be receiving a synopsis of so that they have enough information that they can respond.
Okay, I'm just kind of putting out to you that has been a problem as far as the response, that they're unwilling to respond in the worry that they are going to say something when they don't really know exactly what the person is saying they did. So I don't know how broad that is or how precise it is, but I'm just letting you know that has been a concern in the past about an initial response. I don't know if that's something that can be looked at or addressed, but that it is what it is, and we have not been able to really get past that problem, I would say, and it sounds like it's still a problem. The second, go ahead.
Sorry, go ahead.
Do you want me to make my second point, or do you want to
Yes.
still? Okay. The second worry from many years has been the expert witness, and I really commend you. This is wonderful to be able to talk about this in an open public meeting, and to really sounds like the training is better, you're addressing the issues, and you're looking at past records and trying to resolve problems. But we have talked about for many years the concern about the one expert witness. And I've honestly, I don't even want to say how many years, I've been through many dinners and through many meetings, many meetings with many different veterinarians, and I hear them discuss the same case. I would have done it like this, I would have done it like that. If I was looking at this, that would have been fine. We each did it differently, but the outcome was a good outcome. And so when you're looking at one person who's making a monumental opinion on somebody's career, it has been and continues to be a big concern for us. And I sat through a meeting a number of years ago, and it involved board members, DCA members, et cetera, and I don't know who it was who stood up and said it when we addressed the issue about one expert witness, and I will tell you the comment was, if we have more than one expert witness and they disagree with each other, then we might lose the case. That gave us a lot of heartburn, big, big heartburn, because somebody's life, license, career is on the line. So we have wondered in the past if there's the possibility of having two expert witnesses look at the case. If they agree, fantastic. If they don't agree with each other, it seems like there's a problem. I love the fact that you brought up that the expert witness, and we've talked about this many times also, needs to be in that area of veterinary medicine. If they're an equine practitioner, if they're a small animal practitioner, whatever they are, they shouldn't be making a decision that they aren't familiar with. But the concern of only one person looking at this case, when I know the veterinarians, RVTs, you guys, yes, you have the same education, but you may not reach the same conclusion, and Dr. Grant might look and be an expert witness, and Dr. Pollard might be one, and you might come to a different conclusion. But if you could compare those notes, that would be very beneficial. I wanted to ask Mr. Hepler, we have heard that the medical board has a team of expert witnesses, or a team that looks, or a panel, or something like that. Could you comment on that? Is that true, or?
It's been a long time since I've been in council. They have they do things differently. They have a sort of an intake process. If I recall correctly, so I'll just throw this out. You know, once you pass 50, your memory fades. It's my understanding from the way the medical board works, at least when I was there, is they had intake complaint experts that would review the complaint, and then sufficient whether it to be farmed out for investigation. Then upon investigation, it would be then sent to a different expert for complete evaluation, with that expert probably being, if it ripened into an accusation, that expert would testify. So they do things a little bit different. I'm not, the team concept, if that's what you're referring to, I'm not familiar with, but they don't, it's not a cradle to grave with one expert. There's an intake expert that determines validity to go forward. If I'm getting that, if I remember what Ms. Kirkmeyer said, and then if it's farmed out for investigation, and they have a different model, remember, because they use vertical enforcement, where the Deputy Attorney General and the Medical Board Investigator are like this, so they have a slight nuance, but they don't rely on the same person cradle to grave.
So anyway, I just appreciate you discussing it, because I have seen issues over the past, and I know there's probably financial issues to doing that also, and I know it's not an easy task, but I just guess I want to encourage you to consider maybe revisiting the model while you're discussing it. Thank you.
Yes, Bill.
Thank you. We actually discussed that at our last meeting, having a committee or two individuals, even possibly the task force as it's set, and looking at these. And I couldn't agree more. And that discussion actually came up in an open meeting in MDC years ago, because I was the one that asked the question. And I do think that there is a benefit to that. And, you know, have a group or one or two or three people look at these. Is there an issue? Does it go on? If it does, then send it out and move forward. My understanding, and Anne Marie will correct me if I'm wrong, is that there is in-house that looks at this, may or may not write something, and then it does go outside to an expert. So we know that there's at least two, and we were assured years ago that there would be at least two veterinarians looking at this. But I still think that in addition, I mean, if it could be worked out to have, you know, a couple of people look at it, because just like you said, and we were saying it up here earlier, we're all gonna do things a little different. And we understand that. And I think certainly being a vocal critic as you have been in past cases that we've seen, I do feel better seeing this, how this is working with the people that they have. Is it perfect yet? No, but it is definitely on the right track.
Diana, who wanted to make a comment?
Well, I raised my hand earlier for a very brief comment. Candace,
Yes, ma'am.
are the expert witnesses given copies of the Practice Act?
Yes.
They are,
Mhm.
to keep or just as loaners?
To keep, to the extent that we can. If they're older copies that we're looking at, we may not have that many to go around, so they may or may not be able to keep those.
So
But
the
definitely for the past, I'd say they have the copies for the last 3 years or so.
Okay, so
To keep.
the Practice Act comes in a hard copy in their packet?
When they come on as an expert.
Oh, great,
Mhm.
okay. That's
Absolutely.
really good, in my opinion.
Absolutely, yes.
I can comment on the two expert issue if you want, but I can not as well, depending on the pleasure of the.
Well, you've promised brief comments, and so as long as you do that, that's great.
Okay, my brief comment will be quoting Saint Teresa. More tears are shed over answered prayers than unanswered ones. And if you want two experts, you will regret it. All right.
Wow, that was
Is that
great.
brief enough?
Okay. Other comments from the audience? All right, great work from the subcommittee, so thank you as we move forward. And we will move forward now with our agenda. Let's go ahead and actually take a 10-minute break, and we'll get back to it. Moving on to item 5, expert witness review subcommittee. Anne Marie, do you want to start?
A couple of things. I went upstairs to make some changes to some language that we're going to discuss under the student exemption, but when I did, I had my staff chat with me for a few minutes about the comments that were made prior to our break, and I owe it to them to kind of correct the record. Val mentioned that things were different, and they were, but they have since changed dramatically, and the letters that that we send to the respondent are pretty detailed. And even with those detailed letters, I think it's encouraging that we're getting more and more phone calls from veterinarians asking specifically, what am I supposed to do here? And although we can't provide them legal counsel, we do try to provide them as much guidance as we can about what we're seeking in order to make a determination on the case. And I'm encouraged by how passionate my staff is about the work that they do. In the past, they were told that they can't talk to the respondent. This was prior to the change in regime. They can't talk to the respondent. They shouldn't be providing enough information, or not enough information. They shouldn't be providing any detailed information because, again, it could influence the case. And we immediately changed that because how are you to respond to something that you don't know? And so there has been a dramatic change in how we correspond with the respondent. Oftentimes, we even tell them if we know they've had an inspection and the inspection came through without any major deficiencies or compliance issues, we tell them, look, you've already cleared this in an inspection, you just need to tell us that because this has been a separate complaint filed. So we do try to provide them a complete picture of what we're looking at, and that is incredibly encouraging. It speaks to your question, Dr. Jerseys. We are trying to formulate a relationship with the veterinary profession because, instead of them fearing contact with the board, they need to understand that we can be a resource. And I would hope that all of us would not perpetuate this us against them and the fear-mongering because it really doesn't do anybody any good. It's inefficient, it's not transparent, and we don't get the answers we need, and it's a huge waste of time to our staff. So you're not sure what I said? Siri, okay. Siri agrees. So we should, really move forward in that fashion, and I just wanted to make that statement because I want to acknowledge the work that our complaint unit does and how proactive they've been. So thank you for indulging me.
Thank you. Any questions? Okay. Expert witness review subcommittee, Diana?
Yes, Dr. Pollard and I are on this subcommittee, and I thought we had a very valuable a couple of months during the last meeting. First of all, there was a 2-day expert witness training session here on May 4th and 5th. I was able to attend. Dr. Pollard had gone to a previous one. I tried to talk to every veterinarian in the audience. I talked to all but 3. All of them had been to a session earlier in San Diego, which was a 1-day session. They all were telling me that they got a lot out of this session, and that it was valuable to them. So I was gratified by that. Later, Dr. Pollard and I met with Candace Rainey. And Dr. Pollard and I had sort of seminared pretty intensively our various concerns, my feedback about the 2-day seminar before we met with Candace. And I have to say, it was a 3-person meeting, which lasted pretty much all day, that couldn't have been better. First of all, we had Candace Rainey, who's an experienced enforcement person. You have me, who has represented the board for years, have seen the evolution of administrations and the act. Then we have Dr. Pollard, who's an experienced veterinarian, but a new expert. So couldn't have been better. The expert witness overview, which is here in item 5, is an edited version of what was the rough draft that was part of the packet last meeting. But this expert witness overview was something that the 3 of us staffed. So it isn't all legalese, it isn't all administrative-ese, it isn't all veterinarian-ese. It is hopefully an overview of the important points that you have been talking about, including the fact of harm or the lack of harm. And it is intended to generate discussion at the next expert witness orientation session, because it really generated a lot of discussion amongst the 3 of us, especially Dr. Pollard, who I guess you have a case that you're interested in right now. And that was the kind of springboard that we intended this to be. Because my observation at the May 4th and 5th expert witness presentation was that many of the really valuable points that hit home were the discussions, the concerns raised by new experts, the feedback from experienced experts. Bonnie Markoff was really good, really practical. And and there were a couple of others who had great feedback, practical advice, peer advice, which just can't be beat. So whereas Kurt had this linear standard of care, I love linear, I have my circle of negligence. So I guess lawyers just love circles and lines. That's right. So hopefully that paints some sort of a picture for expert witnesses to key off of. Shared a lot of comments with Candace. My main comment was to enlarge the spent on the expert phase. And to truncate or shorten the first part of the process. In other words, when a complaint comes in, it is staffed administratively, from an investigative standpoint, and professionally. And that's important. It's important for the expert to be assured that when they receive the packet in the mail with the materials and the book, that they are assured that it has been reasonably staffed, reasonably investigated, and looked at by another veterinarian, even though they don't see that report, cannot see it. That's all they want to really be assured of. So you can shorten that by doing some graphics. One of the graphics is, I listened carefully to the questions that were raised. One of the questions was, where do complaints come from? That was really an interesting question. And so we talked a little bit about the hospital inspection program. I think a graphic can be done where you say, okay, complaints come in and they either go nowhere, they go to a citation, they go to the DA's office, they go to Site and Farm, whatever. And they don't go to you, the expert. So you don't kind of need to worry about that. So if that part of the process can be shortened, what was really good, and Candace said that some of the members, maybe all of them in the audience, were able to go up to the offices. But what was really good was the people standing up and saying, I am so-and-so from the admin section. I am Dr. Parvin, one of your in-house, just to see the face of what goes on. But shorten that so that you are focusing on your key audience, the expert. They're the centerpiece of what you want to use your time to educate. So I'm not a big fan of PowerPoints, but I think that's a good tool to shorten that, first area. Let's see. So the report writing, that is the big thing, and hopefully this expert witness overview will deal with that. The use of the expert witness report, again, that's not something the expert witness should worry about, but again, maybe a PowerPoint saying, we decided not to do anything, we're sending it to the AG's office, we're sending it to another agency because, the violations are clear there. It'd be nice to know. The one thing that the experts didn't get was a lot of TLC. And I'm not saying that it's a deficiency of the staff. I think it's more a deficiency of, quite frankly, the DAG. And Diane Sokoloff gave a dynamic performance briefing and listened very carefully. And she said, I worked with the expert witnesses. Well, yeah, the complainant, the investigator, the expert witness. Those are how you prepare your case. And the complainant, as I say, has to be credible. The investigator is usually a very experienced person and is familiar with the courtroom. So, you want a good investigator, that's fine. The expert witness is so important because the rest of the population, except for the respondent, and maybe the respondent's expert, are lay people. So he or she needs to explain at the hearing to translate that into not just what the violations are, but why they're important. And that's true of even the bright line requirements in the act. Why shouldn't, what's the problem with black mold in a sink? Well, the problem is blah-bitty-blue. And the expert witness, I think Anne Marie was saying, it's important that the expert witness is someone who is conversant with that particular area or that particular procedure, because the expert witness is not a percipient witness. They didn't see anything. The consumer saw something or heard something or smelled something. Same with the investigator. But the expert witness is removed. They're only as good as the facts which somebody else provides to them. They may not be facts at all. So they need to be nimble. They need to be able to answer hypothetical questions, where opposing counsel might say, change a fact and say, what if, what if, what if? All right. When I talked to Bonnie Markoff, I do believe, mentioned that she had not gotten a lot of pre-hearing assistance from the DAGs. And I thought that was interesting, because that's key. In my opinion, as a former DAG handling a lot of licensing cases, and witnesses are only as good as the attorney preparing them. And you gotta know your witnesses, especially your expert witnesses. There are some witnesses that are inherently strong, and you can get a lot of good information at the hearing out of them if you just don't object when, say, opposing counsel is coming on strong, because they can handle themselves. On the other hand, if a witness is shy, or this is their first hearing, you may want to be proactive in protecting them. But I am firmly convinced that a witness is only as good as the attorney who's preparing them. I talked to another veterinarian who had written 9 reports, and she had not gone to a hearing, but she had called the deputy in each case to see how or where the case went, and never got called back. Well, she was probably calling the wrong person. She probably should have been calling staff. And so maybe that should be cleared up. Or maybe she just, didn't understand. But I think it's good to reach out to these people, even a brief phone call, and say, how's it going? What do you need to know?
So Diane, I'm a little afraid that we're wandering off agenda.
Oh, sure.
We've got a report here.
Okay.
So if
Yes.
you can speak to the aspects of that. What you have delivered via video is an excellent tutorial for expert witnesses.
Right. Oh, good. Oh,
And
okay.
so I actually hope that it will be captured
I
on the
just
line.
sort of, you told us straight, and I
It's-
just.
It's clearly your passion.
Well, I don't know about that. Anyway,
But
that's
there are some
what the-
pages here I would like
Yes.
you to refer to.
All right.
And perhaps it's been said, but if not, then let's get back on track.
One of the things that we discussed with Candace was spending that quality time, that expert witness, on emphasizing facts. Facts drive this, on talking about standard of care, debating it. What is it? Maybe fact situations to the whole group, and then discussing it. What is standard of care and how you approach it? Negligence, I particularly like the circle, because some boards have gross negligence, so it's easier to explain. You don't. But say, somebody said, I think it was Dr. Grant, hey, I do things differently, but it was okay. it was okay the way this practitioner did it. Well, that's the circle. I wouldn't have done it that way. I don't know. And that makes sense to me. Hopefully it does to the expert witnesses. Incompetence, you just didn't know. And unprofessional conduct. So each of these, it's just a thumbnail. And again, Dr. Klingborg was there the second day. So under negligence, the veterinarian's conduct or non-conduct does not necessarily mean that the veterinarian was negligent in the care of the animal. Conversely, survival of an animal does not mean that the standard of care has been met. We also, at some point, made the point that whatever conduct there was, there has to be a nexus between the conduct and the practice of veterinary medicine. Did you like that?
That was nice, thank you, yes.
Dr. Pollard has some additional comment.
Kind of conflating the subcommittee that Dr. Grant and I were on, we discussed this, Diana and I also, with Candace and Anne Marie, that for future expert witness training sessions, the suggestion was that we present some of our findings from our closed case review. And although I wasn't at the most recent witness training orientation, I was at a previous one. And I can imagine, just like Diana said, that the input from both the enforcement staff and the other experienced witnesses have to be invaluable. And I think we should build on that.
Comments from the committee? Yeah,
But I don't know if it's linear or circular, but for a long time, I had problems with differentiating or defining negligence and incompetence. And I think it might have been Candace that said it, put it in a little different perspective in that negligence is going below the standard of care, whereas incompetence is going below the minimum standard. And that kind of gave me a better visualization of those two components as it relates to the Practice Act. So I didn't see that in there, but it cleared it up a lot better for me than some of the legalese.
Other comments from the committee? Yep.
And maybe Kurt, you can address this. We've seen unprofessional conduct used in a number of complaints, and I thought this was sort of interesting. Unprofessional conduct is variously defined as immoral, dishonest, or dishonorable conduct, or such conduct which is unbecoming member of a profession in good standing. Those are actually behavioral descriptions. Is unprofessional conduct really just pertaining to behavioral? Because there's nothing here that would, I think, that you could use in a lot of these complaints if that's what the definition of unprofessional conduct pertains to.
Unprofessional conduct is sort of a little bit of a fluid term. Generally speaking, the way it works, again, deriving from some medical board experience, general unprofessional conduct can be called generalized unprofessional conduct, and it really is, if you get an expert to say that this conduct, whatever it was, by the part of the licensee, is conduct that is not, is not really consistent with the applicable standard of care. For example, if you get arrested for something and it's deemed substantially related to the standard of care, then the board could discipline somebody, and usually you would rely on the conviction, and then you would rely on an expert to say something like, well, chasing your cohabitant around with a machete is unprofessional conduct, or something like that. So I understand your point. I'm not quite sure that unprofessional conduct is necessarily immoral. I have to be a little bit careful there because, you know, the definition is, like I said, somewhat fluid. I understand your point. Sorry to ramble on, but generally speaking, unprofessional conduct is sort of determined by an expert that such conduct is a contrivance of the applicable act. So I'll just kind of leave it at that.
So it's a broader definition than what this is really referring to.
Generally speaking, yes. Like I spoke of the concept of generalized unprofessional conduct, which means it's not negligence, it's not incompetence, it's not a specifically enumerated ground for discipline. But there's generalized unprofessional conduct that if an expert would find that, yes, for some reason, you know, some pattern, some conduct is not consistent with an in contrivance of the applicable act and its regulations, that could be considered unprofessional conduct.
Thank you.
Can I add on to that?
Yep, Diana?
It's a catch-all. And I'm going to tell the story once again because Candace is familiar with it from the pharmacy board. I had a case where the pharmacist did something related to the practice of pharmacy. But the security camera also caught him using a pair of tweezers to extract dollar bills from the plastic donation box on the counter. Well, you just can't pass that up, can you? So that's unprofessional conduct. You know, he was stealing from whatever charity there was. All right?
Alan?
I'm afraid I can't top that. Maybe that's because I'm just a dumb veterinarian, but it seems, maybe I'm oversimplifying this, but the first two, negligence and incompetence, are knowledge-based shortcomings. And unprofessional conduct is a behavioral-based shortcoming, independent of knowledge.
I would tend to agree with that. I think just so we understand each other. So I think the memo on page 3 pretty much lays it out. So negligence means you know what the standard of care is, you fall below that, okay? In the Medical Practice Act, we differentiate between repeated negligence acts and gross negligence, which is an extreme departure from the standard of care, meaning there's a big gap between the two lines that I talked about, or it's the want of scant care, which means really no care. And so incompetence is a little bit different. Just when we say incompetence means I don't know what I'm doing. I do not have enough knowledge to discharge this act that I'm supposed to do. It's not that I don't want to do the right thing. I don't know what the right thing is. I don't have that base of knowledge. Unprofessional conduct is, I think, a little bit different. It's more of a volitional thing. It's like I chose to do whatever I chose to do because I chose to do that, and that whatever that thing was, it's not consistent with the ethical standards of care, and it's not consistent with the act. So, sorry to ramble on, but that's kind of the way I see things.
Okay. Comments from the audience?
Something specific, so this is not nebulous. In the Veterinary Medicine Practice Act, it does address unprofessional conduct. And I know this has been debated, that it only has to do with drug infractions or alcohol, something that's a criminal violation, but the actual regulations define unprofessional conduct for a veterinarian for failure to establish a DCPR. So sometimes it does have to do with failure to follow protocol. In the world I came from before, unprofessional conduct was in the statute, and it was very specifically defined as an unethical act or unethical conduct. So it is something that can be defined pursuant to the individual practice that you're referring to. But I wanted you to have something tangible in the practice of veterinary medicine. That's not the only place unprofessional conduct is mentioned in the Practice Act, but it does have to do with failure to follow established protocol.
Can I make one last comment? Dr. Pollard and I had extensive discussions about the difference between negligence and incompetence. I think we spent more time emailing back and forth on this very issue. My bottom line is sometimes you just don't know. You just don't know whether a person is willfully ignoring what they should be doing or whether they're ignorant. You just don't know. In the end, it doesn't matter, because it's a violation of the same subsection, negligence, comma, incompetence, comma, and if you have to make a choice, make the best choice you can as an expert, because in terms of violation of the Practice Act, it makes no difference.
Yes, Dick?
I think one of the concerns that I have had with unprofessional conduct is that I see it being used more in the last couple of years. And I see it being used as it relates to medical records. And sometimes I think it is in kind of a way of piling on to a complaint. So I decided to look it up on the medical side, and it does refer very specifically in the dental and the medical boards to 3 specific conditions. And one is overprescribing, one is overusing drugs, and the third is some abnormal sexual relationship with a client. So it's pretty specific there. Maybe it shows up in other areas, but I guess I have some problems when we use it. In addition, when we're using it as it relates to medical records, I think it's piling on. So I think we do need to use it, but I think we need to use it in the areas that we're discussing rather than areas that we already have statute on and regulation.
Any other comments from the committee? From the audience? We are going to move on to the next item and see if we cannot get this one accomplished prior to lunch. So we are moving on to item 6, which is the minimum standards for alternate premises. We have a very nice letter from the brand new president of the CVMA, Ken Pulowski here. Thank you, Ken. And he has outlined for us some proposed language that comes out of this premises task force, which also has myself, Anne Marie, and Dr. Sullivan as liaisons. And so we have on the second page of this, or the back side of the first page, language for 2035.5, duties of supervising veterinarian and animal health care tasks for registered veterinary technicians in the shelter setting. So, going to open this up for discussion amongst the committee at this point. Yes, David.
I'll be happy to start the process. I think this is an excellent start, so thank you to those involved for bringing something forward for discussion. One of the new concepts I'd like to introduce in this category, and then taking it directly from the dental regulations, they have a very nice definition of general supervision. In our Practice Act, we have direct and indirect supervision, and then periodically we use the term immediate supervision. But in the dental world, general supervision means supervision of dental procedures based on instructions given by a licensed dentist, but not requiring the physical presence of the supervising dentist during the performance of those procedures. That's very close to our indirect definition, but when it comes to shelter medicine and the practice of veterinary medicine in a shelter environment, a lot of what the shelters are doing is under general supervision of a veterinarian, because it may not be an employee of that shelter. It might be a practicing veterinarian in the community. So I'm wondering if we could clarify the supervision as more of a general supervision as opposed to an indirect supervision. That would be one suggestion. And then also in item number 2, the supervising veterinarian establishes written orders for. I think, again, we've talked about this. We need to consider the concept of general written orders, which are standing orders, as opposed to me, written orders are the orders that are in an individual animal's record or an individual patient's record. And so I might, again, introduce the concept of a general written order, meaning an example would be all animals 8 weeks of age and older will be vaccinated upon intake. That is a standing general order as opposed to an individual written order in an animal's record. And then under A and B, those most certainly define two very specific tasks that are performed on the intake in a shelter. But I would also add a C, which recommend I'd add a C, that laboratory work is done upon intake. It is part of the disease control process. In other words, animals are tested for parvo, kittens are tested for panleukopenia, cats are tested for FELD, FIV prior to initiating treatment, and in many instances, well before the veterinarian actually sees those patients. So those would just be some general comments that I would throw out of topics for discussion and possible addition.
Yes, Dick.
A group of us were discussing this and thought it would be best to, on B, to address your issue, to add diagnostic testing, treatment of medical conditions based upon animal symptoms.
So you're talking about 2B,
Correct.
adding diagnosis,
Diagnostic testing
diagnostic test.
and treatment of medical conditions based upon animal symptoms.
And I would wonder about using the word, or the phrase clinical signs instead of symptoms. Just technically, symptoms are self-reported and clinical signs are observed, so I would think clinical signs is a more appropriate term. Animals' clinical signs, yeah.
John?
Yes, Dick.
And getting back to your first comment, it was our intention that the, where's the phrase? Written orders were to be general written orders, not specific to an animal. That was the, your first comment, Dave, about saying general orders. That was our intent. It's not meant to be a specific order for a specific animal, so.
And David, I have to say, I don't read it that way, because if you go to the next page at the top where the language 44840B is, in that second paragraph, it talks about RVTs performing healthcare services on animals impounded pursuant to direct order, written order, telephonic order. It doesn't suggest that it's per the specific animal. I mean, it's a grouping of animals.
I'm aware of that, and we've gone back and forth on this one, because to me, a direct order is, you have told me I want you to do this to this animal patient. Written order, again, could be interpreted as what's written in the specific animal's record or a general standing order, and that was one of the things from the very beginning that we were trying to clarify as to, can there be general standing orders that something occurs every time when something happens, and if this occurs, this can't happen without consulting with the veterinarian. I think it clarifies it a little bit. I can live with it either way. I'm just bringing it up as a point of continued discussion.
Yes, Emery.
For the purposes of clarifying what we're doing today, this isn't to extract this language and send it to the board for approval. This is really to have a starting place that we put this out to the sheltering community in October when we're bringing those folks before the MDC, so we can start talking about some of the merits of this. Just for the agenda, for the purposes of explaining this on the agenda, this isn't to consider formalized language before the board.
Yes, Bill.
I do like the term, actually, the way it is, so it does leave it open. And I think when we redid a lot of our minimum standards, it's sometimes we get things too specific and limits things. This way, I'm not sure that we need to change the specific intent. A written order is a written order that a supervising veterinarian, at least in the shelter near us, is the person that does actually write those types of orders and does it. The attending veterinarians are the people that are on sort of the front line. So I think it just infers by the fact that it is from the supervising veterinarians, and the fact that they're establishing this refers back to that type of an order.
two additional items I just wanted to throw out since we're in the discussion phase. In the introductory letter on the first page, bullet point number 2, it says the difficulty of establishing a veterinarian client-patient relationship for each animal. And that was a point that I brought up several meetings ago in my original document, that I think we need to put some language in the definition of the VCPR, because in the shelter world, there are animals where the owner is known, the animal has been seized legally, and we are not going to get the owner's permission to treat that animal. And yes, those aren't high volume cases, but they do exist, and you don't want to force the shelter to be into a relationship they don't want to be in with an owner. And so simple language could be developed to just say, except when a legal case is involved. The other point I'd like to bring up, because it's been brought up before, under this discussion, would be we most certainly could take a look at a RVT, and this falls back into that extended duty category that's coming up later, being the managing licensee of an animal shelter, if we're looking at alternative premises.
Yes.
So with respect to the VCPR and seizing animals, oftentimes, at least in Riverside, that's the sole purpose of seizing the animal, is to provide the care that the owner has neglected to perform. And so there is a client-patient relationship. Well, there's not even a client if you want to consider it specifically, but there is a relationship between the veterinarian and the patient and the legal system. I think that needs to be considered in all of this. The other item that I would like to bring forth is, you're probably all tired of me bringing it up, but that's the issue of induction of anesthesia, or if an ACO does it, sedation. I think there needs to be some clarity in what goes on in the shelters, because oftentimes there aren't any standing orders for these things because they would be contrary to the Practice Act, yet there are certain things that need to be done. And that includes knocking them down to remove foxtails from ears and eyes. Grooming that needs to be done because the poor little beast can't hardly walk. It hurts so much. There are indications for RVTs, I'm sorry to say, that they need to induce anesthesia for the benefit of the animal, independent of the Practice Act, as it currently states.
Yes, Bill.
So Alan, you're considering that anesthesia and not sedation? Because the Practice Act
Anne Marie
is...
and I have had this discussion. For the life of me, from a logic standpoint, I have a tough time with it. If an animal control officer rightfully, duly darts an animal on the freeway,
I think that's
with the
sedation.
same, they're using the same drug, Telazol, at the same dose, it has the same effect on the animal. I'm sorry, it's rendered unconscious.
Well, we could argue about the rendered unconscious part, but it actually, part of it is what the intention is. And there was a case many years ago that went through the thing, and it was the all-care case, and who was sedating the animal, and was it sedation and anesthesia. And part of what the ALJ opined on was, what's the intent of doing this? And in a situation which the discussion did continue, darting an animal wasn't for anesthesia. You are not performing a procedure on that animal. You are rendering that animal incapable of getting away, biting, doing whatever. That's sedation. So I think, and this is something that I do think that we better all, at least on this committee, be very clear with. So, that's why I was asking you, when you're sedating an animal, are you sedating it, or are you really performing, to take your example of shaving the animal down, is that sedation or is that anesthesia? Are you performing a surgical procedure on that animal? And I would argue that you're sedating that animal to either shave it down, pull a foxtail, or whatever. And that is different than anesthesia.
Is this animal that's being shaved down, is it intubated? Is it breathing anesthetic gas?
I can envision that at times it might be, because some of these animals come in so matted that it might take a technician an hour to shave it down.
So Bill, is that animal sedated, or is that animal under anesthesia?
Well, I don't necessarily think a sedation is dependent on an endotracheal tube. There are some people that feel very comfortable with anesthesia with a mask doing a spay and a neuter. I'm not doing that, but that was done and has been done and is still done in some facilities. So, I'm not sure the endotracheal tube defines which way that goes. I think a big part of it is what is the intent. And I would agree. I've seen some of those animals too, Alan, and I would agree it's an hour job. And you know what? That probably is anesthesia. I mean, you need to render that animal unconscious for a lengthy period of time, and we know unless you're giving Tilazol every 15 or 20 minutes.
Just top it off.
Yeah, it's just, yeah.
Jennifer?
I just want to add to the argument between ACOs and RVTs. An ACO in the field is going to take an undisclosed amount of Vitelazol and go dart the animal, whereas an RVT in the shelter will give a more accurate dose, and I may not intubate or mask, but I'm paranoid and I'm going to use a pulse oximeter, and it's going to be receiving, for argument's sake, better care than it would with an ACO who's going to dart it and throw it into the back of the truck and drive it to the shelter. So the sedation anesthesia argument, that's a gray area, but there is a very big need, as Dave and Dr. Juices can back me up, for RVTs to sedate animals in shelter for several reasons, and there's not always DVM present.
And there doesn't need to be a DVM present if it's sedation.
Yes.
Just to keep the discussion going.
Because we've been doing that all day.
This was a short issue before lunch, right?
You notice how I dangled that carrot out there.
Yeah.
We'll try to keep the comments short. When we're sedating the animals in the shelter, it's for therapeutic purposes. It's not for grooming to make them look pretty. It's to alleviate pain and suffering. So there's one of your criteria. With the combinations of drugs that are out there now, the kitty magic, the doggy magic, where you're playing polypharmacy with a variety of drugs mixed together.
Compounding
for the individual patient. I'll leave that discussion for later this afternoon. These animals can stay under for longer periods of time without gas anesthesia. But the comment about ACOs darting animals in the field, we need to take a look at the reverse of that. RVTs will go out into the field to sedate animals for rescue and distress purposes. We get one a month on those, of a dog stuck in a drain, some animal in distress, and the people cannot find a veterinarian that will go out and provide that service. They call their own private veterinarian and they go, that's not our job. And although we try to pass on those services, they immediately then call the fire department or the police department, and then they call us. And so then you're out there, cat impaled on a rebar, dog head stuck in a pool drain. The most common is foot in a bathtub drain. Those regularly occur, and depending upon your interpretations of the Veterinary Practice Act, you're going out to a privately owned animal, providing sedation or whatever you want to call it, to relieve distress and rescue that animal. So those are other things that we need to discuss, not necessarily in this moment, but keep in consideration.
Bill?
I think that this is a great discussion, but probably we should come prepared for this at our next meeting.
Yes.
Just So when we talk about regulations, OAL, the Office of Administrative Law has various standards: consistency, non-duplication, authority of reference, clarity, necessity. I just want to ask two questions, and I realize everybody's running out of hunger pangs, right? So number one, in A, if last time we had some discussion, the term shelter setting, am I to presume that's a homogeneous group? If I understand shelter setting, that word that would be commonly known, there's no.
I would respectfully submit there is a spectrum of what could be called shelter settings.
Okay, so perhaps that would bear on the discussion that's subsequent to this. And then with subdivision 1, the veterinarian has direct knowledge of the animal population. I just want to be clear, is that, am I to presume that the veterinarian knows every animal in the shelter? Because as an outsider looking in, that seems unreasonable.
It's quite unreasonable, and using the example of an animal that needs to be shaved down, that animal just was impounded. If I am at home and it's a Sunday afternoon and an ACO brings that animal in, it needs attention right then and there, and I have not examined it or have knowledge of it, frankly.
Okay. I think respectfully that might require some nuancing in the subsequent discussion as well. I just want to, because one of the things is that with clarity and everything else, consistency, that those terms be somewhat understood in the community that we're trying to regulate.
I think direct knowledge of the animal population, we have to realize that's more of a demographic or a statistical, assessment rather than the individual animal. And so Alan's going to understand he's going to get 2 of these animals a week that need to be shaved down, because that's kind of how it's been restored. Yes.
Yeah, I was going to say the same thing. We're using a large animal term or a large animal practice philosophy here on understanding the population. Large animal veterinarian doesn't examine every cow in his 2,000 herd head, but he knows what the population is.
To speak to Kurt's concern, though, we all know that, but OAL is not going to. So the way that we may need to explain that and amend it is, something to the effect of has direct knowledge of the animal population that is typically served in the shelter setting. We need to close the gap for them, because they're going to say has direct knowledge of the actual population in the shelter at that time receiving care, which isn't what we're referring to here. So there is some way that we can make this more specific. And I just want to add one thing. We really need to look at 2034 I in induce. That goes back to the sedation versus anesthesia. We define induce, but it's an incomplete definition, and then we define inducing anesthesia. So if we want to talk about sedation, it's probably a good time that we define sedation separate and apart from inducing anesthesia. And we have an opportunity to do that on a future meeting agenda and look at 2034 as kind of that reference point for definitions.
All right, I'd like to open this up to the audience for comments, please. Yes, Dan, come on down.
Dan Segna, CVMA. I'm hungry too, so I'll keep this brief. In reference to the section that Anne Marie just off course here for a second on the anesthesia versus sedation issue, when I was involved when this language was developed for induce, and we specifically included the word with the intended purpose, and for the very reasons that were described here. Because any one animal you give the recommended dose could become unconscious, and so just a sideline on that. So to the proposal that CVMA, proposed regulations that CVMA sent to you, I think our letter does a really good job of talking about pretty much everything that the committee did or the task force did and why it existed, and an overview of what they're doing and how we came to this. But I wanted to just go into a little bit more detail on a couple of these things. The task force has had 3 meetings to date, and nearly half of the time that was dedicated to those meetings, so about a meeting and a half, was dedicated to the topic of shelter premises. And as to to get the information that we needed in order to develop regulation or propose regulations. We invited veterinarians that work in shelter situations that are employed by the shelter. We had RVTs that have or are working in a shelter environment without a veterinarian on staff. We've had directors of small shelters primarily, same situation, no veterinarian on staff. And we had a representative from the State Humane Association. And the problems that were identified are in our letter, so I won't repeat those. But our intent here was to try and develop language that was non-prescriptive, but yet served as guidelines. Because one of the things that came to light when we originally started this language, we went down the road of being fairly prescriptive, and then it was, well, what about this, and what about that condition, and so forth. And so, and we also reviewed pretty extensively the protocols, the written protocols from 2 of the shelters that have veterinarians on staff, full-time veterinarians. So with all of that in mind, we developed the language that you have in front of you, and especially today with the risk of being accused of plagiarizing any of this information, we did try to pick up the language that's currently in the Practice Act. And so I will just quickly let you know what those are and hopefully make a couple comments on the issues that were raised here during this discussion. Section A1 comes from language that's in 2034 E and F, direct and indirect supervision, as well as 2035 C, which is the language that we're saying that we're saying won't apply in a shelter situation, but yet the terminology, so we tried to be consistent with this terminology. And also in regard to the animal population, we specifically put the word population in there because we know the veterinarian, even if they're there all day long, can't possibly know every animal that's come in at that point. So it was a concept of the general population, the same way that a veterinarian would be aware of the general population of a herd of dairy cattle, for example, dairy cows. Number 2, the written orders. The veterinarians that provided their sample as far as had written protocols, which I think is what our intent is here, but we went with written orders because that's what's in the Practice Act already. So it could be written orders for protocols under certain situations. In comment to what Mr. Johnson and Dr. Sullivan made on the diagnostic testing, I think we would suggest putting in the diagnostic testing language, but I think it more appropriately belongs under the capital A, because this is something, my understanding is that this is something that's more likely to be done on intake unless an animal is specifically sick. So number 2 was A and B were put in there to identify the issues and address what's being done in shelters for essentially healthy animals that are coming in on intake, and also those that might be showing some signs of disease. And then also for B was a little more generic in the sense of we realize that some animals that are already in the shelter population that are impounded are going to become sick or injured. And so we wanted to leave some leeway for that sort of thing to be for those situations to be addressed also. And as far as the comments on the symptoms and signs, we did discuss that extensively. We thought, and maybe the symptoms were more understanding, but we don't have a problem with going with signs. We thought it was important, based again on reading these other protocols, that number 3, that the treatment can't be going on forever without a veterinarian getting involved. And the protocols that we saw varied from a few days to a couple of weeks, depending on the condition. So again, we feel that should be appropriately addressed in the individual written orders or protocols. We didn't want to exclude emergency care for 2036, so we put that in there. We wanted to clarify that these do not allow RVTs to perform surgery, prescribe, or diagnose, which we got out of 2036A in addition to 4840.2. And then the supervising veterinarian shall maintain whatever physical presence came out of the licensee manager language of 2030.05D. And And then the last thing we wanted to address was that a lot of these animals are adopted out, but when they come back to the shelter, they now have an owner. And some shelters, I believe, offer, the 2-week tune-up or something at that point where they can come back. And we wanted to be clear that this was now a completely different situation, and any disease or injury associated with that owned animal needed to go through the more traditional channels. So that was our reasoning on all of this, and I'm open for questions if anybody has any comments or questions on any of these.
Just have one comment.
Sure.
The diagnostic testing is not necessarily something that would be done on intake.
Okay.
Sometimes when they're held for several days, we start to notice symptoms.
Well, it could go in as a separate C or, whatever. Yes. Thanks.
Other comments, questions for Dan?
Okay. Thanks.
Other comments from the audience? Yes, Dr. Nunes.
Respectfully, everybody, just so one of the functions of the Open Meetings Act is that if we have a quorum of the board present, those that are not a member of the subcommittee can only participate as observers. So in order for you to speak, Dr. Nunes, I would have to ask Dr. Waterhouse or Mr. Bullard, Mrs. Bullard to step outside. That way we would reduce the number of members present and Dr. Nunes can speak. Because right now we have 5 board members here.
I shall wait until they're completely out of the room and down the hallway.
We're gonna listen at the door.
Okay.
They're just gonna look at the podcast. No, knowing that the veterinary medical board only has authority over individuals that are practicing veterinary medicine or premises that are practicing veterinary medicine, has there been any discussion about where this is going to be applied? I mean, we know that there's your official municipal shelters that are practicing veterinary medicine, but there's also private shelters and rescue groups. Has there been any discussion about trying to provide some level of minimum standards for those, or is that, do you think, too monumental of a task?
Stick around for number 7. It'll be short and sweet because we've only just begun, but my intent certainly on this is to bring these discussions to the fore because there are a lot of people around the state that do believe that in some way, shape, or form, the practice of veterinary medicine is performed at locations other than municipal shelters without veterinarians or even RVTs present. So.
And that would probably involve legislative changes, wouldn't it, or?
No, because these things have not been excluded from the practice of veterinary medicine. So if you're vaccinating, if you're doing parasite control, if you're diagnosing, that's still the practice of veterinary medicine. Whether or not those private shelters, rescue groups, humane societies, whether they have a premises permit or not, does not mean they're not practicing veterinary medicine. It's just this misconception in the profession that they're somehow exempt. But it doesn't require statutory change, it requires a great deal of education.
Okay.
Other comments from the audience? Well, we've got our work cut out for us.
We're digging a hole deeper and deeper.
It's a big issue, so. Yes, Dave.
So what's the plan forward if we're having a meeting in October with the shelter community? Is this far enough along to present, or does it need more work?
So I think what I'd like to do is take what CVMA's task force has started, add some of these potential issues to the list of things for discussion. So there'll be a specific agenda that this came out of the CVMA task force, and we've also identified these other areas of further conversation and allow that to unfold. So in no way does this reflect a unified, agreed upon language, end product. This is really just a working document a draft that we've identified other areas of discussion that we'd like to get feedback from the sheltering community.
Any other questions, audience? All right, let's take a 30-minute break for lunch. Well, see you at 1:15. Okay, thank you.